Call the September 4th, 2019 Board of Zoning Appeals meeting to order, and start with Pledge of Allegiance. Pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please, for attendance.
Carrie,
Yes.
Bill Crawford, Jeff Fisher,
Here.
Ruby,
Present.
Leo King,
Present.
Bill McDaniel,
Present.
Jeff Westling,
Present.
and myself.
Okay, well, we're here today. The only public hearing on the agenda is an appeal of a staff interpretation regarding rules of procedure and a table versus continuance and the intent of action and submission of additional evidentiary documentation regarding petition number 14798, petitioner Mark Indiana Bills. Do we need to go through everything for the record? Do you need me to go on and read everything through?
Yeah, go ahead and read.
Okay.
Read all the
Petition
information.
requested action, special exception for public recreational facility. Parcel description and numbers are listed in the agenda. Zoning classification A1. Petition for special exception for public recreational facility at 5554 North County Road 850 West. Begin with bills, please.
Before I begin, I'm Scott Jones. I'm one of the attorneys that represent Mark and Dina Bills. I'm licensed in Ohio and Kentucky. We do have an office here in Indiana. I am not personally licensed in Indiana. The Indiana rules allow me to be here to represent the bills at a hearing. I just wanted to make sure that you all were okay and that there were no objections with that. We do have Kurt Johnson, our Indiana counsel, here also.
No objection.
Okay, great. So I do have a PowerPoint. I don't see particularly well in my old age, so I printed copies out. It might be easier for you all to follow through on that.
Yeah, I have the reading glasses on, so, yeah,
Need one more, I think. we're-
that's beneficial. That'll be beneficial.
Yes. Oh, I'm sorry.
That would be for your.
First of all, I'd like to thank you all for your attention and letting me be here today. Whenever I have the opportunity to represent clients, be it in court or in these hearings, it's a reminder to me that the decisions that happen in here affect real people in real ways. So we certainly appreciate your consideration of our submission today. There's two issues that we briefed. The first issue is the July 8th, 2019 public hearing was tabled and not continued. And the second issue was that because it was tabled, no new evidence can be considered if it was not timely submitted 5 days before the July 8th, 2019 public hearing. So I thought it makes sense to kind of break these down one by one, dealing with the first issue. So what actually happened at the July public hearing? It's very clear. We provided the citations in the briefs that at about 10 minutes and 44 seconds into the hearing, Mr. Naylor made a motion to, quote, table the public hearing for 30 days. That was the only motion made at the Bills public hearing, and it was passed unanimously. The public hearing was then tabled. I think it's beyond dispute that that's what actually happened. The video certainly proves that. So I'm sure you all are wondering, why does it matter whether it was tabled or continued? And it matters for a couple of reasons. One, your rules say it matters. Okay, there is a difference in the consequences and procedures that attach to a matter that has been tabled as opposed to a matter that has been continued. And we can walk through those rules. If you look at Rule 6.4.4, and that discusses a presentation by remonstrance, it allows for the remonstrator to request a 1-month continuance in order to support their opposition and to allow them to supplement the public record with tests from experts and whatnot. So that's not what happened at our public hearing. There was no motion to grant the continuance that was filed by the Doras. The only motion that was decided upon was the tabling. And again, it's important because the continuance, when it's requested by the remonstrator, can only take place for one reason, and that's in order for the remonstrators to generate evidence from qualified professionals to support arguments made in the opposition to the petition. Again, the Dora's request for continuance was not granted at the hearing. Conversely, and what happened here was a motion to table, which is governed by Rule 5.2, which deals with additional evidence. At the very tail end of Section 5.2, it provides the APC is encouraged to table the hearing as opposed to continue for 1 month in order to adequately understand the new information if it involves information of a technical nature or of a revision to original information included in the application. So there's two reasons. One, information has been submitted and APC staff or the APC requires more information to consider that, or two, the information contained in the application was revised. The bills have not made any revision to their applications. And when you look at the video, what you see prior to the vote for the tabling was Mr. McDaniel talking about the submissions, how he had had a very busy schedule, and because of that, he felt that more time should be taken in considering of the bill's application, and henceforth the motion to table. So under 5.2, it's very specific who can make the motion. APC staff, that's what happened here last July. And when can it be granted? Again, two things, to help the APC staff understand new information of a technical nature. Again, that's what happened on July 8th. Or if there is a revision to information originally filed by the applicant. Again, bills have not revised their application. And that, so with respect to information that can be considered after a matter has been tabled, 5.2 speaks to that. So the APC staff making a motion to table is also in the same rule that limits the type of information that can be considered upon a tabling. And if you see, the first part of the rule provides, additional information shall be allowed in the public record up to no less than 5 calendar days prior to the meeting. No information will be accepted into the public record if received within 5 calendar days of the meeting. And again, this makes perfect sense under the rule, because the only way that the APC staff can move to table something is if they have received information within that time frame and they say, look, we need more time to consider that information. Again, that's exactly the scenario that took place on July 9th. A hypothetical. So to say that there was an APC meeting on December 9th, okay? On Wednesday the 4th at 5 p.m., someone submits a technical study of 100 pages. That would leave the APC Thursday and Friday to analyze and review before the meeting on the following Monday. Of course, in a scenario like that, you would expect that more time would be required to review information that was submitted 5 days before the hearing. And we have other sources of information that corroborate how this is supposed to work. In the Dora's remonstrance, they reminded us of the same thing when they provided that, again, the bills cannot submit information, additional documentary evidence, provided not less than 5 days advance of the hearing. We agree, but it applies to them also. And then last, and I admit this is a bit old, but it's important because Robert's rules, which were developed in England centuries ago and provide parliamentary procedure, board procedures, and almost all boards draw their rules from this. And Rule 28 of Robert's Rule says, if laid on the table, if a motion is laid on the table, it carries with it everything that adheres to it. And importantly, when a motion is taken from the table, everything is in the same condition. It's a timeout. That's essentially what a tabling is, which is again, different than a continuance. Once the timeout is up, the same information that was submitted at the time the timeout was called is then considered. Now, what cannot be concluded in the APC public record? Again, is anything that was not provided to the APC 5 days before the July 8th hearing. We noted in the amended staff report from Mr. McDaniel that there's specific references to the DORA's CFO application, which was submitted on the very day of the hearing. Again, that cannot be considered because the matter was tabled. That concludes the presentation. Are there any questions that you all have about it? Thank you very much for your time.
Actually, I have a few, if that's
Sure,
okay.
of course.
I think part of it is just an understanding and maybe sort of an explanation about typical protocol here. Typically, just like most counties, we don't see a lot of controversial issues. Every now and then we do. Pretty familiar with those controversial issues. I was on the board during the last several of those that have gone through. And our practice has always been, I'm not saying that this is a basis for a decision, but our practice has always been to accept information from anybody that wants to provide us information at any time. Because as a board, we want every piece of information that we can have at our disposal to make the best decision we can on the day that we get to make it. And I guess my question to you is, if we completely agree with your appeal and we strike from our memories everything that was submitted prior to that date, do you truly believe it would substantially change our decision?
Ms. Steele, I can't accurately predict how you all feel about this case, how you're interpreting the evidence. The thing that we're asking for today is we have a set of rules. The rules are there for everyone. They're there for the doors, they're there for us. All that we're asking for is that we follow these rules. And when we start today with the Pledge of Allegiance, that's really meaningful. That's part of the reason why I was so attracted to the practice of law, because I believe what that Pledge of Allegiance means. And for me, it means that whoever walks through these doors, they're treated equally and fairly with the equal application of the law. And those words really mean nothing unless the decision makers who have that authority choose to apply the rule of law fairly to everyone. So that's all that we're asking.
Okay. Anybody else have any other questions or?
Would there have been any change in the matter if we had asked for a continuance? Was this
Different
just a
wording.
mistake in our lack of knowledge as to proper terminology?
Ma'am, no. To be direct, under the rules, the APC staff can only request to table a matter. Okay?
Okay.
The remonstrator can make a request to continue the matter. And again, as we went through, whether a matter is tabled or continued attaches different consequences. Okay? So for instance, I'll give you an example. Mr. McDaniel sent us a memo today about the other appeal that was filed and whether to proceed with the DORA's application in October. And the suggestion was, well, everyone can submit briefs or additional evidence by September. Well, that severely prejudices us because, one, we're dealing with an incomplete CFO application, okay, that presumably they're going to provide supplemental evidence for probably on September 26th. And we have the burden as remonstrators.
I don't really want to get in. Can we not have I understand you're using it as an example, but this is not the place to discuss whether or not we hear or don't hear or go down that line of that.
No, I'm just trying to make the point that continuances and tabling, they have different meanings and they attach different consequences.
In practice, and Jeff, I know you weren't here for some of this, but in practice, the board has quite often, just because we weren't, if we get a packet that we're unsure of, in practice, we quite often table or continue things with no differentiation between the two within the wording. So my question to you is, as a board, I feel like he's made a very good case that there's only very, very specific circumstances where we can table or continue. But I know in practice, we have done that a lot for all kinds of reasons. I mean, things from, everything from I had to take my dog to the vet to I didn't get a chance to read it. We've continued things for much more flimsy reasons than what we did here. That's my
Basically,
question.
there's been a history of conflating the two.
Yeah, so my question to you is, from your perspective, what do you think about the difference between continuing tabling and whether or not it came from Bill or the board, or how? I'd like to hear your viewpoint on it.
Before we get to that, can I ask Mr. Jones one question?
Please.
So talk to me about 4.2.3. And that's where it discusses essentially a public hearing that's been recessed, okay, which is a third piece of language that we can all compare: continuance, table, recess.
Correct. Yeah, and if you look at the rules in terms of what new evidence can be offered in that scenario when a matter has been recessed, again, and that's not what happened. We had not started our
I
presentations.
apologize, and I don't want to interrupt you, but
Sure.
I want to break this down so it's clear. So you would consider that not to be a recess?
That's correct. It's tabled.
That would have had to been requested to be a recess?
That's correct.
Okay.
Well, that's,
So that's a third, I mean, we can, I know we're lawyers and I know we can have fun with the language, but continuance, tabling, and recess to you all have three different meanings?
they do.
Okay.
They do as the rules that you guys have written, not rules
Well,
that
none of the rules
I'm
are-
making up.
None of those words are defined, correct?
Well, they are defined in the context of the consequences that attach to them. So they are used differently, and because they're used differently, they attach different consequences. In the context of a recess, it talks about new information being provided. That's only after the start of the presentations. So whether whether the matter was recessed during the applicant's presentation as opposed to the remonstrator's application. Again, that didn't happen in our case because the matter was tabled prior to any of the presentations.
So you would argue that it didn't happen during the petitioner's case?
That's correct.
Okay. Because it happened after the application was called and then it was before it even got to there, that's the argument?
That's correct. We did not make any presentation of any evidence or any arguments at the public hearing.
Okay. And if this board would have then called that a recess, what would be your argument against any new information being presented after that date?
Well, I think under the rules, it would not have been a recess because, again, no one had started their presentations.
Okay. And recess is defined as that, or does that just give you a remedy what to do when that happens?
No, I'm looking at the term recess as it's used in this paragraph.
Okay.
And based upon its use in this paragraph, it applies in a context where either the applicant or remonstrator has started their presentation and the matter is recessed. And if you look at further down in the rules, it's typically because of time, that you guys don't want to be here till 1 o'clock in the morning. And I certainly know as much as anyone, once attorneys get talking, it can certainly lead to very late evenings.
Okay. And then let's go on to 5.2 then. if we
Yep.
can. So your interpretation of 5.2 is that knowing that you have to give the information, both sides or all parties have to give the information no less than 5 calendar days prior to the meeting, unless it's got voluminous documents and it's got to be over 10 days, correct?
If that's to be considered in the public record.
Okay. Now my question is, do you believe that this board or the APC or the BZA can hear from people that have not given anything to them prior to that meeting?
I don't know that I follow your question, sir.
Do you believe that someone can come and speak on behalf or against an applicant without having previously met with the APC, without giving them any documents?
I believe there's a public hearing that anyone can talk.
Okay.
I think what these rules apply to are matters that will be put into the public record, which I presume to be those what would be considered by the BZA during deliberations.
And if someone came, a non-applicant came, either for or against, and had documents, had copies for every board member, and gave them all to each board member, Do you think that that would be permissible?
I do not.
Okay.
Now, whether they could read them is a different question.
Okay.
So I think there's a distinction under the rules in terms of what would be considered the public record.
Okay.
Those documents themselves would not be in the public record, but if someone wanted to read them, they would be a part of the public hearing.
Okay. So if the Doras were to come in opposition and they were to read what they have actually handed to us, you think that would be appropriate?
I don't know whether it would be appropriate, but I don't think there's anything that would stop them from reading anything into the record at a public hearing.
But it's the distinction of actually the document becoming a part of the public record.
Exactly.
Which is,
So if they read it into the public record, you think that that's fine, but the actual handing over the document being a part of our file would be inappropriate?
I guess I'm stumbling on the word fine. I don't think there is anything that would prohibit them from doing that. That's what you're asking me.
Okay.
But I do not believe that if they have documents that they come forward with at the public hearing, that those can be entered into the public record.
And you would agree that tabled, nor continuance, nor recess are defined in these rules of procedure, correct?
I did not see any definition section. The definitions that I come up with, again, are based on context and by the APC's use of different words to mean different things.
this APC or different, like,
Your rules.
I don't have any other questions.
Thank you.
is it appropriate in, because I'm not, honestly, there's not very many appeals, so is it appropriate to have is there another side to this? Do we hear what?
Well, I think that you could certainly have anybody else that wants to speak to the issue that would have anybody that wants to speak to the issue.
But I didn't know, like, if it was a public, I know it's a public hearing, but I didn't know if it was an open.
Sure.
So, anybody else like to speak or have anything else to say on the topic?
This may be very surprising, but Jeff Rocker for the Doras would have something to say. At one point, just quickly, if I may have clarification, Mr. Jones indicated that we agreed that the bills would be barred from providing more information within 5 days. That's not correct. That's a misquote of what we said. We said that if their continuance was not granted, if the hearing was held on the actual case on the original date, that they would not be able to provide new information then. A little bit different, I think, but meaningfully different. Secondly, I think that I agree with Mr. Jones and your counsel that these terms are not defined. I think that the discussion and the intent was clearly, and the rules in general, the intent is, if you've given your information, you don't get a second shot at it. If you haven't given your information in the public hearing, you get to say your piece. And I think that sounds like the way you folks have always operated, and it's generally the way I think things operated at BZAs and APCs throughout the state. Nobody said anything at the July 8th hearing. So I think to bar anyone from saying their piece at another hearing in the future is contrary both to the spirit of the rules and to the way this council has operated. Another point I think that bears mentioning is sort of a twofold piece. One is Dora did ask for a continuance. That continuance was never ruled on. I think Mr. Jones said that. It wasn't denied. It has never been heard. That continuance presumably would then allow us to, under the arguments made tonight, to submit new information. So here we are back to square one again. Secondly, I think it's an interesting point is this hearing has now been tabled and continued. So now what do we do? It was tabled in July and it was continued by Mr. Bill's own motion in August. So under their argument, if it's been continued, you do get to send more data in. So here we go again, back to the same spot. So I suppose it's all very neat and tidy and interesting for people who are sick and twisted and interested in the vagaries of the practice of law, but I don't know that it amounts to a hill of beans in terms of how we actually get the data to you to make an intelligent, informed decision. So that being said, I leave it to this body to make the hard decisions as you always have to do. I suppose that one way or the other, Mr. Dora gets to bear the brunt of this decision because he's the one that's being silenced as to what he can give this board. So with that, I leave it to you. Thank you.
Just as a point of clarification, are you contending that during the public hearing, the actual public hearing, that, I apologize, something you said that made me, I just want to make sure that that they can't present at it, or your argument is more about the pieces of paper they sent us prior to? I want to make sure that
That's exactly right.
okay, it's about the paperwork that was mailed in a timeline that you don't agree with. It's not necessarily that we can't proceed with a public hearing like we normally would, that they could come, they could say whatever they want. Like, it's about the submittal of the
The
paper.
secondary remonstrance.
That's exactly right. It's about the evidence that constitutes the public record.
Okay.
Correct.
Any discussion or questions for probably Mr. Wesley?
So the appeal is specifically what? That you're asking of us tonight?
The appeal is that the motion that was made at the public hearing be treated as what it was, a motion to table, and not a motion to continue. And therefore, that the documentary evidence that can be considered is limited to those that had been received 5 days before that public hearing.
Before the July 8th meeting?
That's correct.
So essentially, the Doras presented, gave us documentation on what day?
I forget the date of the
7th or
the
6th.
second package.
Yeah.
The first package was insufficient time because that was there before the 10 days because that was in the initial package. So it was the secondary package, which was the small package from Mr. Dora's attorneys, and then also my references to the in the timeline of the confined feeding special exception submission.
So essentially, what they want is for us to remove that from the record and to not consider it unless it's unless or if it is submitted to us during the public hearing
And read in.
and read in. That is the
Yeah, but we can't accept
And
the
yeah.
documents as part of the full public record, but they can be written in. Is that essentially it?
Yes, the documents are cut off from being a part of the public record 5 days prior to the public hearing.
Yep.
I have a question. So somebody can get up and speak and say what they want to say, but it can't be put in as part of the hearing. So I guess, if you hear something, it's gonna,
Okay, well, I think, Jeff, it's like, say someone has maybe a couple page document. Now, they can't give it to us to go into the actual record
Right.
with the files I keep, but they can read it,
and we can
which,
consider it.
yeah.
so by them
That-
reading it, we're all hearing it, and it's gonna affect your
Yes, and you
decision.
can consider it at that point. If
That's-
if the remonstrators chose to read it in, we would be able to consider
Accept it.
Yes, if they read it in.
It seems-
Rule 5.2, just to clear up that issue, it says, "No information shall be handed to members of the APC at the public hearing unless it is to be presented or read into the record of the hearing."
Entertain a motion.
Yeah. Now, what you would do as the motion is to accept the argument made on behalf of Mr. Bill's attorneys that it was tabled rather than that the intent was irrelevant because of the language, and then the particular documents referred to cannot be used by us and then you in making your decision unless, of course, some of those are read into at the public hearing.
Yeah, so you can, so the motion would be either that you agree with the appeal or don't agree with the
Yeah.
appeal.
And that's the thing is that, so what you're doing is, okay, is this, because of the way the language was in the rules of procedure is written is that basically that we use the improper language is irrelevant, according to Mr. Bill's attorneys, that the intent is irrelevant and based on the language. I mean, because, yeah, these are the rules that we have, and are we gonna follow the rules that we have based on just the way it's written in that interpretation?
Then we had to follow our rules. Is that what you're saying?
Yeah.
I make a motion that we accept this appeal, that we tabled the meeting, and anything that we received before the August 8th meeting cannot be considered
Okay,
July.
okay, within the
July
5-day window
No.
before.
The things that, no, it was the July 8th meeting.
Yeah, the 5 days before the July 8th meeting.
Yes, they had to be here before the July 8th meeting, not the August meeting.
Yeah, yeah, the
August
the
meeting,
5-day,
we just
anything that violated the 5-day
Accepted
window
the
of
appeal
submission.
request,
Yes.
and nothing was done.
Okay.
Do I hear a second?
Okay, can we massage the actual language?
To what?
Okay, it's the, yeah, that's the, okay. So basically what you're saying is, Leota, is that the appeal, you are accepting the appeal that we, okay, we actually tabled under our rules rather than continued.
Yes.
And then that, anything after submitted for the bill's petition, after that 5-day window has closed, to not use.
I think that's what she said.
Yeah, okay.
I think
I
she
just
said
got
that
little-
pretty clearly.
Okay, well, I just, yeah, okay, I just wanted to be clear that that was it.
Yeah, I mean, is that your understanding, Jeff?
Yes.
Ruby?
Yes.
It's my understanding of Leota's motion is that, did he characterize it correctly? That you're accepting the appeal as it was presented essentially?
Yes.
Okay.
I
Go ahead.
I'll second it.
Roll call?
Carrie Steele,
Yes.
Bill Crawford, Jeff Fisher,
Yes.
Ruby Seidler.
Yes.
Leota King.
Yes. All right. The appeal was carried. If we accepted the appeal, we will not consider anything submitted within the 5-day timeline from July 8th. We look forward to the public hearing in about a week, I guess. Is it-
Less than a week.
Yeah, less than a
Yeah.
week.
Monday.
Monday night.
So I'm assuming that you will notify the Area Plan Commission of the decision tonight
Mhm.
so that they have that
Yep.
for their decision
Will
making.
you let us know which paperwork we cannot consider?
Yes, I will let you know specifically again. And what I'll do is I'll look to see the exact document because those of you that received the email, I will let you know by email. And so you'll have the date, also the email. Ruby and Jeff, well, you are already here, so the only, okay, well, I'll need to.
And let's get an email chain going with
Yes.
all council, and so we can agree on what documents should and should not be taken into account.
If I may, I might suggest we just have like a clean email that has whatever documents. that we-
Yes,
instead
like
of
these are the
look at
only
this one.
things, this is
Yes.
what is being, I would totally agree with that.
Yeah, okay. So the, actually, it's probably easier if we just have the email of what is,
This
rather
is,
than-
this is what's accepted, rather than not this, not that. I want one document to open up that says this is what I'm allowed to use for my decision. Does that work for you?
actually, I might be a little easier too because there's so many things that were little things here, little
Yeah,
things there.
it may not be combined into one
Yeah,
PDF, I
but-
understand
but-
that,
But clearly stating the one that, okay, basically the documents that are strict.
Before we give that to the members, though, we're gonna have
Yeah.
council all get together, so that way we don't have this problem, right?
Yes.
And we have, I think we have all of that electronically, if that helps.
Yeah, because I pretty much, oh God, I have so many damn emails over this the last 2 months.
We will have a hard copy of this decision in the office within 5 calendar days. So you're aware of that.
Okay, do I hear a motion to adjourn?
I make a motion to adjourn.
I'll second it.
So moved. Meeting adjourned.
Thank you.